All right, today we're diving into a huge Supreme Court case, Roper v. Simmons. And look, this is way more than just a story about one crime. This is a story about a battle for the very soul of the U.S. Constitution. We're talking about two incredibly powerful legal ideas going head to head. And you know what? The entire massive case really boiled down to this one single question. Does the Constitution forbid executing minors? I mean, think about that. Can the state execute someone for something they did when they were a kid? The answer, whichever way it went, was going to completely redefine justice for young people in America.
Okay, Section 1, a question of punishment. So, how did this even get to the Supreme Court? Well, it all started with one person, Christopher Simmons. He was sentenced to death for a crime he committed when he was only 17. His entire appeal rested on this fundamental challenge to the Constitution. Was his sentence cruel and unusual?
Now, you gotta understand the path here was anything but straight. I mean, just back in 1989, the court had actually said, yeah, it's okay to execute 16 and 17-year-olds. But then, something changed. In 2002, in a different case, the court banned the execution of the mentally disabled. And they did it by citing something called evolving standards of decency. That phrase, right there, that became the key that unlocked the whole debate over the juvenile death penalty just a few years later. And right at the heart of this whole legal showdown is the Eighth Amendment. Specifically, that little phrase, cruel and unusual punishments. But what does that actually mean? Seriously, does it mean what it meant back in the 1700s, or is it supposed to change as we change as a society? The entire case, everything, was going to hang on that one question. All right, let's get into the arguments. Section 2, the majority opinion. This is the yes side, the argument that the Constitution does, in fact, forbid the juvenile death penalty. And this was the opinion written by Justice Anthony Kennedy. So Justice Kennedy's whole case was built on this one really powerful idea, evolving standards of decency. What's that? Well, at its core, it's this philosophy that sees the Constitution as a living document. It's not some dusty old relic. The idea is that the meaning of cruel and unusual shouldn't be frozen in the past. Instead, it should reflect the moral compass of a society as it grows and matures.
So for Kennedy, it boiled down to something pretty simple. Are kids fundamentally different from adults? And his answer was a resounding yes. He pointed to three huge differences. First, a simple lack of maturity and responsibility. Second, they're just way more vulnerable to peer pressure and bad influences. And third, their character, who they are, just isn't set in stone yet. You put all that together, he argued, and it means they are less culpable, basically less blameworthy, than an adult who commits the same crime. And to prove that society's standards really had evolved, Kennedy brought out one simple, really powerful number: 30. That's it, 30. Because by 2005, 30 states had already banned the death penalty for juveniles. For him and the majority, this wasn't just some small trend. This was proof of a clear national consensus against it.
And this right here, this really captures the two opposing corners of the ring. You've got Justice Kennedy on one side, arguing for a living, breathing Constitution. And on the other side, you have Justice Antonin Scalia, who is about to come in with a completely different and very powerful view of what the law means.
But remember, Kennedy's view was just one side of a very divided court. So now, let's look at the other side. Section 3, the dissenting opinion. This is the no argument, led by Justice Scalia, who argued that the Constitution absolutely does not forbid executing juveniles.
Now, Scalia was a giant in the legal world, and he was a champion of a philosophy called originalism. And it's basically the polar opposite of a living constitution. Originalism says you have to interpret the Constitution based exactly on what the people who wrote it understood it to mean way back then. So in his view, if executing a 17-year-old wasn't considered cruel and unusual in 1791, well, then it can't be considered cruel and unusual today. End of story. It doesn't matter how much our modern opinions have changed.
And you can really feel his frustration in this quote from his dissent. He basically accused the majority of stealing power from the American people. He said the court was making itself the sole arbiter of our nation's moral standards. For Scalia, this wasn't about interpreting law anymore. He thought the court was just making up its own moral code and forcing it on the rest of the country.
So what about that national consensus Kennedy talked about? Well, Scalia went right after it. He basically said, hold on, your math is all wrong. He pointed out that Kennedy's number, 30 states, included 12 states that had banned the death penalty for everybody, not just for kids. Scalia said that's irrelevant. He argued if you only look at the states that actually have the death penalty, a majority of them still allowed it for juveniles. So he asked, where's this big consensus you're talking about? It doesn't exist. And then there was this other huge point of conflict, international law. Kennedy pointed out that the U.S. was basically alone in the world on this, one of the only countries still executing juveniles. He saw that as confirmation that our standards had evolved. Scalia's response? Whoa, it was blunt. He said the opinions of other countries are completely, totally irrelevant to interpreting the U.S. Constitution. He wrote that the very idea ought to be rejected out of hand. You just can't get more opposite than that.
So there you have it. Two brilliant legal minds, two completely opposing philosophies, and one deeply divided court. The tension was palpable. So who won? Let's get to the final word.
And get this, the whole thing came down to a single vote. It was absolutely razor thin. By a margin of just 5-4, the victory went to Justice Kennedy's side. So this wasn't some big, sweeping agreement. It was a fractured, contentious decision that really showed just how divided the court itself was on this fundamental issue. And so, on March 1st, 2005, the final ruling came down. The Supreme Court declared that it is unconstitutional to impose the death penalty on anyone for a crime they committed when they were under the age of 18. The evolving standards of decency had officially evolved. The impact of this was immediate, and it was huge. Just like that, the sentences of over 70 inmates sitting on death row were overturned. But even bigger than that, the decision drew a brand new line in the constitutional sand, forever changing the landscape of juvenile justice in America. But really, when you step back, the legacy of this case is so much bigger than just the juvenile death penalty. It's a perfect snapshot of this huge, ongoing debate we have in America about the Constitution itself. What is it? What is it supposed to be? And that leaves us, you and me, with the exact same question the justices were wrestling with. Should the Constitution's meaning change with the times? Is it a living document? Or are we supposed to be bound by the original understanding of its authors from centuries ago? Roper v. Simmons gave us an answer for this one specific issue. But that fundamental debate, the one about the very soul of the law, that's a conversation we are absolutely still having today.